here today to the first meeting in 2017 of BPP University of Volunteers Legal Series, Constitutional and Legal Series. Tonight we are going to discuss the implications of triggering Article 50 and the judgment which the Supreme Court handed down earlier today.
She has asked me to summarise really what has happened this morning. I think, putting aside the political significance of what's happened, it seems to me, certainly as Dean of the Law School, that this is the constitutional law case of the century, certainly so far, possibly in the last 50 years. And I think it's striking that this students of constitutional law has almost everything that would possibly want from an exam paper of constitutional history. So we've got a relationship between Crown and Parliament, we've got a relationship between courts and the Crown, a relationship between Westminster and the devolved powers, a relationship between the courts and leading Parliament, the UK and the EU, the difference between treaties, Act of Parliament and so on. So it's an incredibly rich source, I think, of examination questions for many years to come. I'm sure everyone is by now has read the summary of what happened this morning, the judgment was handed down. But very simply, it was, as we all know, part of an appeal, it wasn't part of an appeal against the High Court's decision that an Act of Parliament is required to trigger Article 50. And the Supreme Court dealt with it by co-joining three Brexit-related cases together and then answering some very narrow questions. I think that's the first point to make. That there was really only four very narrow points that the Supreme Court was considering. And the first one is saying that the High Court considered, namely, is an Act of Parliament required to trigger Article 50. In other words, you need an Act of Parliament to invoke the procedure by which a member state withdraws from the European Union. There were then three more complicated questions in some ways, well, politically complicated questions, I should say. What is the position of the Northern Irish Assembly? Let's say an Act of Parliament is required, then would the Northern Irish Assembly have to assent to that before the Act is passed? Likewise, does leaving the European Union have an impact on the Northern Ireland constitution, and therefore would the people of Northern Ireland have to vote in some way on that matter, or be consulted on that matter? And then last of course the Scottish question, would the Scottish Parliament also have to give assent for triggering Article 50, or perhaps actually slightly more narrow than that, but would they have to be consulted, I think, before Article 50 was and of course we know that the main case was brought by Gina Miller, and her lawyers, of course, argued that the Crown, or as we would say today, the government, cannot use its prerogative powers to remove rights that exist in domestic law unless Parliament has said it can, essentially. My school students routinely answer questions on this incredibly important but quite subtle and nuanced area of constitutional law, namely the extent that prerogative powers are exercised, and they still exist today, in what format, and what do they look like. Obviously central to that argument that her lawyers put forward was that the consequences of triggering Article 50 would be to remove rights from people, specifically those, of course, which her lawyers argue flow from our membership, specifically flow from our membership of the European Union. Obvious examples would be unemployment law, and the question is what would happen to those rights if Article 50 were triggered. Could those rights be lost in some way? So, 9:35, we've heard the decision. I had it on iPhone speaker in my office. Is an Act of Parliament necessary? Yes. And it was a majority decision of 8 to 3 that the Parliament cannot trigger Article 50. The government, sorry, cannot trigger Article 50 without an Act of Parliament. And that vote would have to involve an Act of Parliament which has to be considered by both houses. On the second point, in the Northern Irish Assembly, the answer is no, consent is not needed. The answer to the third question, the Northern Ireland constitutional point, the answer is also a definitive no, and Scotland also, the answer was no. Well, that's an incredibly quick summary. I don't know if my colleagues want to add anything like that. Gloss it. Oh, good. I hope it's after. So that's where we're at now.
Okay, thank you very much, Peter.
I'm going to talk about two things. I'm going to talk second about what I said in the pamphlet, which is still applicable and still, I think, important. And that's about the question of whether litigation is a good way to settle constitutional issues, and the problem of the interaction between politics and law in the way cases are framed before the court, so that the court doesn't get all the different possible points of view and doesn't even get all the best arguments. And just to anticipate my conclusion, my view is the government could have won this case, but didn't want to. At least objectively didn't want to, because it didn't put forward its best arguments. It preferred political considerations to legal ones in the way it argued the case. Whereas the applicants were the other way round. They put forward arguments which were politically very damaging if you're someone against Brexit, but they were determined to win the case, and they won the case. But I'll get back to that. So I just wanted to preface talking about that with some obvious points about the way our legal system works and about how legal thought works. Because in many ways, this was an entirely orthodox decision. An entirely orthodox decision about the relationship between law and politics. And that comes out in a number of distinctions, which I think are very important to put on the table. I'm sure John later will attack them. But these are the orthodox views of our legal system as it's developed over the past centuries. The first distinction is a distinction between a treaty and a domestic law. Our system is that the government can make treaties, but those treaties do not in themselves change our law. This is not, as the court points out, to protect the government, it's to protect Parliament. Because it means that the government can't arrogate to itself the ability to make new law simply by making treaties with other countries. And that distinction itself is fundamental to the case. Because the government was claiming a power, it admitted, to change domestic law by actions to do with the treaty, that is, by withdrawal from the Treaty of European Union. It shouldn't have admitted that. Actually, there's a shaking of the head in the front row. This is because it's rather incredible the government actually did concede that point. It technically conceded on what are called the Category 1 rights, the replicable rights. It conceded the point that what it was purporting to do was to change existing rights, and they attempted to justify doing that. And my main point in the pamphlet is that it shouldn't have done that. That's how it lost the case. But that distinction is utterly orthodox. The second distinction is between laws and resolutions of the House of Commons. The people of this country are sovereign, but they express their sovereignty through their representatives in Parliament, and specifically when those members of Parliament help to pass laws. All other expressions are simply political expressions. And so a resolution of the House is not a law. A law is a statute passed by the procedure that statutes are passed by. And that procedure allows for extensive debate in 3 stages in 2 Houses of Parliament. So simply passing a resolution, which the House did on the subject of Article 50, is not the same as passing a law, and the court is really clear that it's not enough for Parliament to pass political resolutions. It has to go through the whole process of passing a law. The third distinction between politics and law, though, goes the other way. That is between conventions and rules of law. So there's a convention, the Sewell Convention, which is about the relationship between the Scottish Parliament and Westminster. Not, by the way, between the Scottish Government and the British Government. It's between the two parliaments. And this convention, put very crudely, says that the UK Parliament shouldn't change the law within the scope of the Scottish Parliament except by consent of the Scottish Parliament. But the court decided, and this is again entirely orthodox, that those conventions are purely political matters, to be decided politically. It can't be enforced in court. In fact, the whole idea of a convention is that it's not legally enforceable. And then finally, and I think the thing that, the issue that prompted this meeting in the first place, on the question of referendums. The court is very clear, in fact both the majority and the dissents are very clear, that referendums don't change the law. Referendums are political decisions. They can't authorise what is otherwise unlawful. That the people are sovereign through their representatives in Parliament, and that is not changed by having a referendum that didn't say what its consequences would be. Now, it might be politically not a good idea to defy the will of the people as expressed in a referendum. Other people might take a different view. But whichever view you take, the law is that those referendums are politically but not legally significant. And because there's a French lawyer in the audience, I should say that this is really important. It's really important to understand this, to understand the rather surprising reaction of the President of the French Republic to the referendum. Because the President of the French Republic, Monsieur Howarth, on hearing the result of the referendum, said, well, that's it. The people have decided. That's because Article 3 of the Constitution of the Fifth Republic says, in France, that the French people express their sovereignty through their representatives and through referendum. That's not our constitution. We are not governed by the constitution of the French Fifth Republic. We're governed by our own constitutional arrangements, and that's what they are. So, coming back to the point I made in the pamphlet, these are all entirely orthodox distinctions. But the government, I think, could have made its case more compelling. In particular, it could have made its case more compelling on the meaning of the European Communities Act 1972, in particular Section 2. What the government said was that all rights and obligations that were brought into UK law from European regulations, not from directives, which is different, they said, but from European regulations, which are directly applicable, that those rights and obligations would disappear in a puff of smoke the instant Britain left the EU as a matter of international law. And by admitting that, they admitted the main point of the applicants, that the invocation of Article 50 threatened existing rights. This is not just about rights that might be created in the future. It's not just about the situation after Britain leaves, about new European legislation. It is the existing rights and obligations of British citizens as they stand now. And the government was in effect claiming a power retrospectively to void all those rights. Not surprising, therefore, they lost. But I think they needn't have done that. They could have gone for an interpretation of Section 2, which would have said not that all existing rights under regulations are destroyed, but only that ones in the future were. And the question is why they didn't do that. Why did they put the cut-off point earlier than when we leave? And I think the reasons for that were political, because it sounds like we're going to be under rule of the European Union for longer than they wanted to admit, and also because it would have rendered the so-called Great Repeal Bill a rather smaller and less significant matter, because it would have been an argument that you needn't in any way pass legislation to save those rights and obligations. On the other side, however, the applicants were determined to win the case, whatever the political cost. And that's why they argued, and the court in the end didn't decide one way or the other on this point, they argued that an Article 50 notice is irrevocable. That once you issue Article 50 notice, the applicant said, once that's happened, there's no going back. That in many ways was an attempt to strengthen their own case, but from the point of view of a Remainer, that's a catastrophic thing to say. Now, fortunately for Remainers, the court didn't decide whether Article 50 notice is revocable or not. It's just an illustration of a different set of priorities of the two competing sides here. The government put politics first, the applicants winning the case first, and as ever, people more determined to have higher priority on winning tend to win. And to come back to what I said in the pamphlet, that's one of the reasons why litigation is not a great way of settling big constitutional issues, because the full set of arguments are rarely before the court. Thank you.
My argument is not, of course, therefore, against the Supreme Court, but against some of the interpretations that have already been made of it, and indeed some interpretations of the law and of the Constitution that were being made before it. Let me just quote. These will be familiar ideas, I think, to all of us now, but I'd just like to quote a couple. One is by the distinguished and rather voluble philosopher A.C. Grayling, who talked about this as being, let's say, the attempt to use a referendum to bring us out of the EU as a gross subversion of our parliamentary democracy, a subversion of our constitution, a coup. The idea that the royal prerogative is simply a feudal relic and therefore has no validity or ought not to have any, which is a very commonly expressed view. And the view that was expressed after the judgment in this evening's Evening Standard, just let me quote a little bit of it. The ruling plunged the Prime Minister into battle against MPs and peers seeking to shackle her over any Brexit deal with other EU nations. And Mrs. Gina Miller, who first, as you know, brought the case, concluded from the judgment, I quote, that Parliament alone is sovereign. Parliament alone is sovereign. If this were true, it would be a strange perversion of our history and of our political system and indeed of common sense. But I'm not going to argue the law. I'm just going to argue what I think is some conclusions that derive from our historical experience. Our constitution, after all, is the creation of history. We've never had a constitutional conference that has laid down our constitution. It has just grown like topsy. First of all, Parliament is not sovereign, with the greatest respect to MPs and former MPs in the audience. Parliament is not sovereign in the absolutist sense that Mrs. Miller and others think it is. Parliament has the absolute right to pass laws. The Victorian legal expert Dicey, who's always quoted on these occasions, made this very clear. It has the absolute power to legislate, neither more nor less. It cannot give orders to a government or to the army or to the civil service. As David pointed out, a parliamentary resolution cannot act as an instruction to the government, and MPs cannot give orders to the servants of the state. They have tried in the past. They tried during the 1640s. It didn't end very happily when Parliament proclaimed itself the absolute sovereign, indeed made it high treason to deny it, and the Speaker of the House of Commons was made the head of state. But Oliver Cromwell came in with a squad of soldiers and kicked them all out, as you probably know. That showed what sovereignty really was. In that case, power grew out of the barrel of a gun. I'll stop your prating, he said. And of course, as we all know, he said to one of his soldiers, take away this bauble, the mace that represents parliamentary authority. So Parliament is not sovereign in any absolute sense. The Crown and the royal prerogative have their proper role in our constitution, as they do in all modern states. The executive, call it whatever you like, the royal prerogative, or you can call it other things. But it is the power to govern. And indeed it must, in a sense, be independent of parliamentary dictation, otherwise it could not be as it must be, politically responsible to the electorate too. Montesquieu, the great French, 18th century French political theorist, pointed out that the separation of powers was the foundation of liberty. For one part of the state to take into itself all the powers of sovereignty would be the foundation of tyranny. I'm not saying that the House of Commons is aiming at tyranny, but it's worth bearing in mind that the separation of powers between legislative, executive and judicial powers is well established in most constitutional states. And finally, I think my main point is the role of the people, the ignorant masses who have been so much criticised for not knowing what they were doing. People like that have always had a crucial part in our history, not simply because they sometimes rioted, but always a proper and accepted and legal role. Well, sometimes a slightly extra legal role in times of emergency, but always a crucial role in our history, in the deposition of monarchs in the Middle Ages, in coronations, and of course in the great changes that took place outside the law, such as the 1688, the Glorious Revolution, which was not carried out by Parliament or by the courts, but was brought about by the people who met in meetings, some of them in armed meetings, in county meetings, who insisted that Parliament should put into law what they, the people, wanted. Okay, this was a rather messy process, but it was a real process, and it's the foundation of what we think of as our modern constitutional system. Not discussion in a constitutional convention, but the role of the people in the streets and the fields. And the idea that it's illegitimate for people to make these great constitutional decisions seems to me to be a denial of the most important elements of our history. So in conclusion, the great institutions of state, Parliament, the Crown, the courts, exercise sovereign powers. But whose sovereign powers are they? It's not very evident, I think, the answer. But David said it earlier on, it's the sovereignty of the people, or if we prefer, the nation. If that sounds a bit too French, the first French constitution made it very clear that all power comes from the nation. No one has the right to exercise power that it does not come expressly from the nation. Of course, we've never gone for these absolute statements of principle, but we've always accepted throughout our history that the consent of the people is essential to legitimate government. And it's clearly the case now that the people, the majority of the people, no longer consent to being governed within the EU. And it would not be legitimate for the law courts or for Parliament to try to thwart the will of their ultimate sovereign.
Thank you very much, Rob.
Someone who's always wanted to be part of a movement to restore the sovereignty of the British people and the sovereignty of their Parliament, I'm obviously very pleased with the way most things have gone in the last year. I do think all sovereignty resides in a democracy in the people, and they express that sovereign power once every 4 or 5 years when they can throw out Parliament and choose parliamentarians more to their liking, or they can endorse the popular government and tell it what they wish it to do next. And we have now added in our constitutional development that they can, from time to time, be given important, difficult questions to resolve, and they will resolve them and make the decision. And I was in no doubt, I don't think any normal person could be in any doubt, that the referendum passed the decision to the British people. It was not advisory. Ministers made it very clear in Parliament that we the people, would make the decision. Both sides in the referendum campaign kept stressing how important it was that people voted because they were making the decision, they were not merely expressing an opinion. And so I think it's very difficult to argue that Parliament can do other than enact the wishes of the British people. And we are strengthened in that conclusion by the fact that 6 to 1 of all MPs voted for that referendum when the Prime Minister and the Foreign Secretary made it clear that it was passing the decision
to the British people. So what happens now? Well, the government will comply. It will produce what I hope will be an extremely short and clear piece of legislation based on the very narrow point that Parliament has to give authority to send the Article 50 letter. Parliament will be fully engaged in the process of leaving the EU because there will be a much longer and more complicated set of procedures to repeal the 1972 Act. So there was never any intention to bypass Parliament. It was always going to be very engaged, but it will now have the benefit of putting through a very short bill. And I believe that will go through quickly. The SNP and a few Labour MPs will be against it, the Liberal Democrats will be against it, but they number about 80 or 90. We know that from the vote we've already had on this issue, and so we expect to see it carry the Commons with a thumping majority. And I'd be very surprised if the Lords wanted to say no to something which had majority consent of the British people in referendum, and then a very strong majority coming from the House of Commons. And the precedent is very clear. Their lordships did not seek to prevent the referendum. They gave the referendum bill fair wind, and they gave it fair wind knowing that it was passing the decision to the British people. They were very open about that, and many of them joined in the referendum campaign, stressing to the British people how important this issue was, and the Remain side were constantly telling us that the Article 50 letter would be sent the day after we left, and after we'd had the vote, if we voted the way they didn't want, and they made it very clear that we were making the decision. So I think all will be well. I think everybody's behaved fairly impeccably. The government has accepted the judgment. Their lordships have wrestled with their legal arguments. I thought 3 of them were exceptionally wise, and the other 8, I thought they did very well on most of the questions on the scholarship paper, but I wouldn't have given them full marks for the one they did on how Parliament should decide on the issue of sending the letter.
Thank you very much, John. And now I think we've got Jonathan Clark in the United States.
The Supreme Court explicitly said that the briefest bill would be sufficient where that court had no need and arguably no authority to say anything about the nature of the legislation it called for. And again, I think that will have an impact when the Commons comes to consider this. Nevertheless, I think there are important points here. Since 1973, authority has ebbed away from the Westminster Parliament to the EU Commission, and Parliament pretended that this was not happening. However, it was happening, and it created a power vacuum at the centre. Now, 2 practices or institutions are drawn to seek to fill that vacuum: the referendum and the Supreme Court. Which will prevail? Will Parliament reassert itself? Nobody can predict the outcome, but it will be helpful if we have a clear historical analysis of what is going on. So how does this case illustrate the wider scenario? I answer, the arguments of counsel on both sides and of the judges address the problem that the legislation at issue did not contain what the judges call clear words that provided for the situation that has just arisen. And we're talking especially about the European Communities Act 1972 and the European Union Referendum Act 2015. The lawyers on both sides therefore argued by inference. But the question is, if the legislation was incomplete, who or what now makes provision to supply the gap? The referendum, Parliament, the courts? This is now open to argument for 2 reasons. First, a new animal has arrived in the arena, the referendum. The judges want to ignore it, but that does not mean that it will go away. Second, the Supreme Court is developing an activist understanding of its role, echoing the European Court of Justice, rather than the conventions that prevailed before the Supreme Court was created. We can see that the judges in the Divisional Court invented a new sort of statute, which they called a constitutional statute, which they deemed to be more important than other statutes, and which could be interpreted only by them. but their precedents were only other court cases from as recently as 2003 and 2014, not primary legislation. So much for the supremacy of Parliament, we might think. So the Supreme Court judgment doesn't uphold parliamentary sovereignty. On the contrary, it tells Parliament what to do. It ignores the fact that Parliament could already have chosen to pass such a bill to trigger Article 50 on many occasions since the 23rd of June last year, but had not done so. On the other hand, Parliament could have voted out of office a ministry seeking to use prerogative powers to trigger Article 50, but Parliament had not done so. The consequence, then, is that this judgment politicizes the Supreme Court. This was perhaps inevitable, but it ends the fairly recent illusion that the judiciary is apolitical, just as the behaviour of Sir Ivan Rogers showed that we no longer have an independent, apolitical civil service. The judges, no doubt, acted with the best of intentions and with the highest sense of professional integrity. But this episode reminds us that judges are unelected and unaccountable, and that they wield arbitrary power. It may be, if I could conclude, that the long-term outcome will be to strengthen the new practice of the referendum rather than Parliament. But I am an historian, and let me emphasize to you, nobody knows.
Thank you very much, George.
Many years ago now, I was Shadow Europe Minister. At the time, the Conservative Party's policy was to seek a gradual return of powers and competences from the European Union. We happened to fix social and employment law as our first target, but we were very clear that the real point was to establish a precedent. Many of us didn't particularly favour the vehicle of a referendum, not least because when you hold a referendum, you never quite know what the outcome of it might be. And it always seemed to me that as we look at all of the academic studies of what happens in referendums, the great weight of evidence is that when you hold a referendum, it is always much more likely that it will end up endorsing the status quo, regardless of the strength of the arguments, because that is the way in which the public mind tends to work. They tend to go for the less risky option. And the really remarkable thing, I think, therefore, about this referendum that we had last June was that it went the way that it did. Perhaps by a small margin, but it was quite astonishing to get that vote for the dramatic change rather than the easy, casual endorsement of the status quo. Looking at the events of the last few months, I, like many of my colleagues, think that the Supreme Court ruling has been an interesting thing to observe, but perhaps in some ways a little bit of a sideshow. The politics of this have been clear. The British people were asked to decide by Parliament. It was made clear by both sides in the referendum that that judgment would be final. As John said, it was made clear by the then Prime Minister that Article 50 would be triggered immediately following a vote to leave. There was really no doubt in anybody's minds that this was the decision being taken and that it would be final. So I think really it would have been better to put the vote before Parliament sooner. I think we could have introduced this very simple piece of legislation in the autumn. Many people, I've no doubt the distinguished lawyers will take the view that it's very important to have resolved the point of the law. But I think there's very little doubt that if we'd introduced this simple bill, it would already have passed through both houses of Parliament. And I think the political reality that we face as we look at the balance of public opinion on these matters, I think it's pretty clear that over the period since the referendum, whilst people haven't in large numbers said they've changed their mind about the decision they took then, I think there's been a steady increase in the number of people who voted Remain, who have come to accept that a decision has been taken, have accepted that this was a democratic process, that the people had made a judgment, and they've started to accommodate themselves to it. And just another observation on the balance of opinion, looking at my own colleagues in the House of Commons, I'll just share with you a phone call that I had a couple of weeks before the referendum result from somebody who runs one of the big opinion polling companies, who at that time was pretty confident that the vote was going to go to Remain, but said, Graham, it strikes me that as chairman of the 1922 committee, you might have some interesting conversations in the days and weeks following the referendum. It might be helpful for you to know that just before the campaign started, I did some polling of members of parliament. He said, I never published it. He said it was a sample, like any polling, but it was robust. And he said it told me that far from what Conservative MPs have said their view is on the referendum, 75% of them indicated that they personally would be voting to leave when it came to the referendum. So when you look at the Conservative benches in Parliament, it's pretty clear that there is a significant will for this to happen. When you look now increasingly at the other side of the House of Commons and see the number of members on the other side, particularly Labour members, who have started to accommodate themselves to the reality of the referendum vote, I think it becomes pretty clear. So I just close, Sheila, by coming back to, I think Robert raised the Evening Standard leader, in which he said that they claimed the PM was being plunged into battle with Parliament. All I can say is, sitting in Parliament, it really doesn't feel like that. And today, the statement following the Supreme Court ruling, my observation is it didn't feel all that electric in the chamber. It felt quite flat, because I think most of the House of Commons has accepted that it gave this judgment to the British people, and the British people have exercised that judgment, and it's now our responsibility to see it through.
Thank you very much, Robert. I think on that note, we are going to close with thanks to Jonathan and Redwood, our absent speakers, to all of you for speaking, to all our panel here.